NHS Darlington CCG and others.
My Lord, before Mr Locke gets underway, two bits of housekeeping and two answering points my Lord raised or correcting a factual matter. The first is the housekeeping. You've got the Advocate General's opinion for ABSUR and for, in the official version, for IEFA on your desk.
Thank you very much indeed.
ABSUR, I would propose we paginated it to go in at tab 25 of Authorities Bundle 2, or B. Give me a minute. Pass a minute. And just so nothing takes my learned friend by surprise, we would say the relevant passage in that is paragraphs 45 to 48, dealing with the question of prior prescription. And my Lord Justice Underhill might note in particular paragraph 48 at page 591H, where the Advocate General stresses that the Article 3.1 provision is to enable pharmacies to produce on a small scale tailor-made products for individual patients, and he footnotes for that proposition at footnote 26 paragraph 64 of Advocate General Sharpston's opinion in Aventis, which is the paragraph you asked me quite a few questions about yesterday. So
yes, how interesting, thank you.
Thought that might assist. ABSUR, IEFA rather, should go in place of the unofficial version that we had at tab 28 of Bundle C, as is the way sometimes with the CJEU, the official translation took a long time to arrive.
Yes.
It's only just landed. I should also point out, my Lord, I can confirm that none of the orders for reference in any of these cases are available. The CJEU, as of about 2 weeks ago, has started to produce translations in all the national languages of orders for reference, not just the questions, but the full national order for reference. And I've checked. None of the orders for reference in IEFA or Apposite are available.
Well, thank you for checking.
Aren't they usually in the official journal, questions?
The questions are, I'm talking about the full
Oh, I see.
20 page order for reference with all the facts set out by the National Court, which they've begun to publish very recently indeed. Then the second thing I need to draw to your attention is this. Mr. Peretz asked my clients a question yesterday of what happened in the German proceedings after the German proceedings went back to the National Court. And I should give you the answer I gave him, which is, in summary, at the Landgericht level...
This is in Apposite.
This is in Apposite. At the Landgericht level, the Landgericht concluded that there was a modification. It was then appealed to the Oberlandgericht, which concluded that there was no modification. And the basis for that conclusion was that the packaging changes, etc., which had been the subject of argument, themselves didn't amount to modification. The court concluded that what they were looking for were...
Sorry, there's a slight distraction here. It's
Strange echo in the room.
Always nice to hear one's own voice laid back. Don't worry at all. But are we now good?
They concluded that what they were looking for were changes in the composition, biological changes, etc. And the case was decided on the basis of burden of proof, on the basis that Novartis had not established that the medicines produced by Apposite had in fact changed. Now, given that the evidence had been locked in below and had been focused in on packaging, that's an unsurprising conclusion. We have prepared an unofficial translation, vetted by my German-speaking clients and by Miss Ewart, who is a German a national, and we've prepared it electronically, provided it to my learned friends, and we'll supply it to the court. You have my point that, with respect, none of that's relevant. If, as we say, the question is, first of all, risk of change, and secondly, you have evidence or materials before you and arguments before you that weren't before the German court. So that's the second thing I wanted to address.
Was that the end of the German proceedings? Or was it
That was the end of the German proceedings, yes. Then I was asked a question about pre-filled syringes and whether there was evidence or not. And the honest answer is there is no evidence. And
This is about what you're telling us about Lucentis having
Yeah.
invested
What's
a
that-
great deal of time and effort.
What I can say in public is that the process of development, from my client's perspective, from beginning to end, took 5 years. I'm not willing to say anything more in public about it because you'll understand that one of the particular difficulties I have is that in the world outside this court, Miss Stratford's clients and my clients are vigorous competitors.
Yes, but I don't worry. I really wasn't wanting to explore any more detail. I just wanted, for good order's sake, to know
Yes.
whether what you were telling us was in the evidence anywhere, and your answer is no, it isn't. I don't think that matters too much because that sounds entirely uncontentious, but I shouldn't be referencing some passage in the evidence.
If you're interested, there's a single document that demonstrates all of the processes. I've discussed it with my learned friend Mr. Peretz and Mr. Locke. We're happy to provide it to them on a confidentiality basis.
No,
Very,
it really was a very narrow inquiry on my
well,
part.
I'm just trying to be of assistance. The last thing, my lord, I should mention, Moorfields. I suggested wrongly yesterday that the reason for the Moorfields recall was contamination. It wasn't. You can see the full facts in relation to Moorfields in my learned friend Mr. Peretz's client's report, Sup B 22 at 350. It is in fact a deeper point. It wasn't conventional microbial contamination. There was something about the manufacturing process itself, the bottom of which was never arrived at.
But again, is this in the evidence anywhere?
It is, yes. Supplementary B 22, page 350.
So, okay, if we want to discover more, that's where we'll find it.
Yes.
Okay.
That I'll sit down.
Thank you very much. Yes, Mr. Locke.
My lords, my lady, you should have two documents from us. One is a single page sheet headed structure with respondent submissions, which is designed to be a route map, so you know roughly where I am planning to go, subject to the court, of course, sending me off in another direction, which of course you've always got the right. And secondly, there is a note to respond to the wholesale dealing issue, which is the new point. I anticipate getting to that this afternoon. I don't invite you to read that now, but
But if we have nothing better to do over lunch,
if you have nothing better to do over lunch, well, I'm
Very
sure
well.
the Lordship will have far better things to do over lunch. Anyway, the substance of our submissions are that this matter is not nearly as complicated, I'm afraid, as Mr. de la Mare paints it. And essentially, the point, the flaw in the approach from the appellants is to treat the system that regulates them as actors in the market for the manufacture and distribution of medicinal products in that economic market as applying to decisions taken at a state healthcare level. At a very simple level, it's applying the rules that fit the supplier to the customer. And, my lords, can I just invite your lordships to pick up our skeleton argument, which is at tab 4 of the first bundle. And invite your lordship to turn, the ladyship to turn to page 81, paragraph 10. And if you'd be kind enough to reread paragraph 10, I know you've read it and you'll be very, very familiar, but of your lordship.
there's a missing word, isn't there, after required? Oh, I see. No, there isn't. That's a verb. So sorry. No, it is. Anyway, the general sense is
My dyslexia
required
comes
for.
out
I
again,
think.
I'm afraid.
I think it must be required for, as my lord
Yes,
says.
required
Yeah.
for. I think it
Okay.
must be, yes. and I won't take your lordships to it, but for your lordships' reference,
But the trouble is that these phrases outside the scope of EU law, I'm not quite sure what that means in this.
I think it means outside the scope of the directive for these
Yes,
purposes.
I know it means outside the scope of the directive, but I don't know what it means. What does it mean to say that something is outside the scope of it?
Well, my lady, I'll take you to my submissions in due course, but without wishing to spoil the main part of the play, so to speak, by giving you a taster. Effectively, what the directive does is it doesn't regulate medicines per se. It regulates the activities of actors in the medicines manufacturing distribution market.
I see. So it's the prescribing which is outside the scope.
Yes.
I see.
And therefore, if you are not a person who is doing something which is prohibited or regulated by the directive, which is concerned with the actions of actors in the market, then you are not doing something which is within the scope, within the details of the directive.
My lady put to you, and you agreed that your point was that prescribing was outside the scope. But if I've understood you correctly, you go a bit further than that.
Yes,
The
I do.
administering.
And the administering, yes.
Yes.
And
The internal arrangements, at least within a hospital, that lead to the administration.
Precisely. And indeed, if it is correct that Hospital A supplying Hospital B is downstream of placing on the market, that activity not being a placing on the market and not being something which requires a manufacturing authorisation if it's taken by a pharmacy is not something which is within the scope of Article 6. And if it's not within the scope of Article 6, it's not something which the directive regulates, then the question about whether or not you're entitled to do that is purely a matter of national law, not an EU law point. Provided, of course, that where relevant, you abide by the rules of the directive, and that you abide by other aspects of EU law, non-discrimination, for example.
It's all going to come down to, as indeed it did for the judge, placing on the market.
It does. And I'm afraid that's going to come back again. But, my lord, I'm anxious to sort of get there in a logical way.
Yes, no,
Can I start by asking the question, and hopefully answering it, did the CCGs act unlawfully in concluding that treating wet AMD patients with CB was clinically safe and clinically effective? Because, as your lordship will appreciate, a large amount of material in this case is essentially, the case has been presented as this, that the NHS shouldn't adopt this policy because it may produce a medicinal product which is unsafe, and there are a whole host of reasons why it would be a bad idea, and safety and its modification, it's got risks, and what the NHS should continue to do is to continue to purchase their product, which has the guarantee of the EMA process to ensure that it's safe. And the question, therefore, as to whether it is safe to treat patients with CB is somewhat surprisingly right at the centre of this appeal, and was in the centre of the case below. And we say that matter has been looked at exhaustively by the National Institute for Health and Care Excellence, which is known as NICE. And if your lordships would be kind enough to pick up the judgment, I should say, my lady, I'm not proposing to take your lordship very much of our skeleton argument. You've read that, and the arguments I'm going to make will flow from it, but I'm not going to constantly refer back to. But I will take your lordships to the judgment, because many of these issues were accurately summarised by the judgment. It's at tab 9 of the first bundle. And if I can invite your lordship to look at paragraphs 51 to 53, and I know you've read it, and I won't take you through it, but it's simply as a reference point. That's where the judge summarises the functions of NICE. And the functions of NICE are to give advice about NHS services. And therefore what it does is it gives advice about the way that medicines can or should be used to treat patients within the health service. It's not giving theoretical advice, it's giving practical advice about whether or not a particular medicine is safe to be used on UK citizens as part of the health service. And NICE set up a project to look at the diagnosis and management of age-related macular degeneration, and there's been reference to the project. And that was a very extensive project which considered every aspect of the diagnosis through to the treatment. It wasn't just a project which looked at these 3 drugs. It went much wider, looking at the whole process of the management of this condition, how it's diagnosed, at what point you should start treating it, where it's cost effective to start treating it, and if you are going to start treating it, how you should treat it in all its various presentations. And a decision was made within that project, again, I think as you've been told, that instead of looking purely at the licensed, or the drugs which had use within their summary of products and characteristics, their SMPC, for treating wet AMD, they would look at all anti-VEGFs that were used. And the evidence considered by NICE was hundreds of clinical trials across thousands and thousands and thousands of patients, and international practice concerning the use of these 3 drugs. And that led to a 250-page report which covered all aspects of guidance about the treatment and diagnosis, treatment, including observations about the safety, the clinical effectiveness and the cost effectiveness of different drugs to treat wet AMD. And the conclusions, and if I can take your lordship to Supplementary Bundle A, tab 20, this is the short summary at the beginning of a 250-page report. And that report was below, it's not before...
Sorry, which is the short summary? What we have here is passages from the 250-page report, isn't that
yes,
right?
Yes, what your lordship has is at page 290, the beginning of the document, and the first pages through to 326 are essentially the first chapter, which constitutes a summary. And moving to page 318.
Sorry to be a nuisance, just so I can understand that. If you look at the contents page at 292, going over to 293, you've got chapters, if they're called chapters, 1 to 4, which end at page 36, internal page 36.
Yes.
So that's what we've got.
That's what you've got.
So you're calling it chapter 1, which
I'm sorry.
It doesn't matter at all. But are chapters 1 to 4 really a summary of everything that follows? I think
Yes.
they are. Are they?
Well, they are the
4 is.
Four
yes,
is the summary of recommendations,
Yes, I see. It's a slightly odd structure, but I do see
It is,
it.
which starts at page 316.
Okay, thank you.
I'm sorry.
I'm trying to work it out from there. Yep.
Essentially, pages 1 to 27 are a summary of the process that has been followed, and some of the diagnostic
Methodological matters.
methodological.
Yep.
Then you get some of the recommendations, and then you get a large number of pages that essentially explain why they've come to that
Yes, I see.
conclusion. And at 318, paragraph 318, page 30 of the report, recommendation 22, be aware that no clinically significant treatments in effectiveness and safety between the different anti-VEGF treatments have been seen in trials considered by the guideline committee. So, what all drugs have risks, and these three drugs, two drugs used on label, one used off label, were exhaustively examined by all the clinical trials. Now, yesterday, I think the point was developed that this was a purely research-based project, and it didn't look at the risks of compounding and the risks that the compounded product would be less safe than that in the research.
Can I just ask you about that recommendation, 22, because there's a difference, isn't there, between observing no clinically significant differences, which is the text of the recommendation, and what you see in the footnote, that the guideline committee's view that there is equivalent clinical effectiveness.
And safety.
Observing no differences is not the same as saying the two things are clinically identically effective, is it not?
In fact, the footnote arguably goes further, because what it says, as your Lordship rightly notes, is that given the guideline committee view, there is equivalent clinical effectiveness and safety of the different agents. It'll be effectively, I summarise, it's more cost effective to use the off-label
The
version.
phraseology used in the other document you asked us to look at last night, is that reflected in 22?
Yes,
Footnote 2 appears to be going a bit further, as
Yes.
you say.
and my Lord, as you rightly say, what I invited you, the court to look at last night were complaints made by the pharmaceutical companies that the compounding process had sufficient risks that, in fact, the conclusion of equal safety should not be drawn. And we see that in particular at page 232. And my Lord, picking up the point that my Lord Justice Floyd made, we see at 232 there's a reference in italics to an observation which is later in the report. So you don't have the report, but you know what it says because this is what they were objecting to.
Which bit are you looking at?
It's in the middle of 232, middle column, comments. These are comments coming in from Bayer. Recommendation 1.5.2, or 0.4/21 includes.
The wording is tinily different. It's essentially the same as final recommendation 22.
It is. I don't think there's any difference in substance. And the point, and the objections are made that the quality, safety and efficacy of unlicensed products is uncertain. Below, the compounding process can include the risks. There's then a reference to the Moorfields incident on the following page at 233. And the the response from NICE is in the third column, which essentially is, we very carefully considered this.
Really see what their answer was, apart from on page 233, that they'd assumed a scenario in which 20% of people were getting endophthalmitis, and they said that didn't matter to the net balance of benefits and harm.
Yes. So,
Well, that's a bit worrying myself.
well, my lord, can I put it this way? We are not the experts. NICE are the experts. NICE have a very large team, and they're internationally respected for doing precisely this type of work. And they have come to the conclusion that these three drugs, in practice, have equal clinical safety.
You were meeting, and at the point that was made yesterday, which seemed to be saying that this was based on product produced for the investigation, and therefore did not look at the risk, or did not consider the risk that the compounding that was done would be done in practice.
Yes.
Would create risks. I think were you going to say that that wasn't right, that amongst the hundreds of clinical trials or thousands of patients you referred to, did those include looking at people who had had these injections in other member states, administered to them outside the context of a clinical trial?
Well, all that evidence of international practice, my lady, is precise, as far as we understand matters, is precisely what the what NICE would look at. They'll also be influenced.
Well, but do you, by international practice, do you mean in the field, as it were?
In the field, sorry, yes, in the field. And they will also be influenced, and rightly influenced, by, for example, the observations of the World Health Organization, which is, and I'll be taking your ladyship to this in due course, which, again, in practice, only recommends one drug for treating ocular conditions, which is compounded bevacizumab. And that is, again, a practical recommendation from the WHO as to which drug they recommend for treating among other conditions, including wet AMD. Not in theory, but in practice. And the evidence is that was before the court below, and certainly I can take you to it, that Roche applied to the WHO to ask them to remove that recommendation for practice, because they said that it's an unlicensed drug, and they didn't support its use for ocular use. And the WHO's expert committee looked at that and refused Roche's application. Now that's clearly relevant, peer-reviewed international evidence that NICE would take into account. So there's a body of evidence, and I'll take you to Lordship and Ladyship to in due course. But I'm focusing on a very narrow point at the moment, and can I come back to the point I'm focusing on, which is this. The legal question in my submission is whether the CCGs rationally reach the view that for NHS patients being treated with NHS wet AMD patients, it was equally safe and equally clinically effective to treat with compounded bevacizumab. Now, of course, I accept that at the time that decision was made, we had the WHO material, but we didn't have the final version of the NICE guidelines. But we had it all in draft, and there's very little distinction between the draft and the final guidelines. We now have the benefit of the final guidelines, so obviously we're referring to that. But essentially it's a rationality point. And the rationality issue is whether or not my client acted lawfully in reaching that conclusion.
Am I? This isn't a head-on challenge on the basis of safety, as I understand it.
No, well, I'll come to that. in a moment.
I think, is this, I don't know if this is your understanding, I think it's mine at the moment, that the question of safety is deployed in support of the claimant's construction of the regime and how the regime impacts in this situation, because it says that questions of safety would not be properly addressed if. This is not a case, I haven't looked at the original claim form, or at any rate not for a long time, where one of the challenges is it was unreasonable of you to decide this was a safe product.
No, well, I'm building a submission, and Your Lordship is perfectly right. I'm building a submission, but what is important, Your Lordship is absolutely right. So, because if Your Lordship would go, having there being no rationality challenge to that conclusion, we then go to the judge's judgment on whether this drug was indeed safe in clinical practice. Now, of course, I accept that it is possible to argue that even if this drug is entirely safe, because that's what the judge concluded and no appeal against it, because there is a possibility that unlicensed drugs or off-label prescribing would be unsafe, you have to bear that possibility in mind when adopting a proper construction of the directive. I accept that argument. But it's not this case. That is solely what I'm concerned about at this point. And because if Your Lordships and Your Ladyship would turn to paragraph 47 of, 47 of the judgment, we get a decision at the end of a series of paragraphs that I'm going to take a bit later. The CCG is entitled to take its own view on the clinical effectiveness of particular medicines. My submission, that's plainly right. And we then go to 154 to 162, where the judge dealt head on with the question of fact as to whether Avastin was safe for ophthalmic use. And from 154 to 162, the judge considered the objections raised by Mr. de la Mare, which we see at 156, and there'll be a certain echo of those today: risk of compounding, shelf life, stability, and so on. Looked at the NICE report, but before that point gets to 159 and notes, as Your Lordship rightly said, there's no rationality challenge, and then concludes at 161 that the judge proceeded on the basis that Avastin is of equal effectiveness safety to either Lucentis or Eylea when used to treat wet AMD by intravitreal injection. And I invite the court to accept three things about that. First of all, that's a conclusion of fact.
Well, I'm not sure it is. The judge wasn't herself, and I don't think any court, certainly this court, will be very slow ourselves to set ourselves up as the ultimate arbiter of safety. The case hasn't been run in that way.
No.
I don't think the judge was saying, I have found this. I think what she was saying is that
I proceed on the basis.
I proceed on the basis that,
Yes,
and she's already rather carefully explained the ways in which this issue only come, if you look at 154, what she's really saying is that the challenge has been raised on this basis, but it's not quite clear how it fits in.
Yes.
It does her best to see how it does fit in.
Yes.
Yeah.
My lord, but and quite rightly, and what we say essentially is this, that the reason that this whole aspect of safety is problematic is because it's unclear how it fits in, save as an aid to construction of the 2001 directive. Because it doesn't go any further, because actually the evidence of safety comes not from a body which is concerned with law, but a body which is concerned with safety and clinical effectiveness, which is nice. And it has conclusively, and it has reached a very clear opinion on that, and that they are the body that make, certainly for the NHS, are tasked with making those decisions. And the argument that they were only concerned with theoretical safety and not practical doesn't flow from either their terms of reference or indeed what they said in response to precisely those complaints. But my lord, it goes further than that, because of course the position that these drugs should not be used should be used for wet AMD patients is not only the position of NICE, it's also the position of the Royal College of Ophthalmologists. And this professional body made its position very clear, and that's summarised by the judge at paragraphs 18 and 66. And I won't take you to it because you've seen it, but essentially the Royal College is very strongly in favour of the use of Avastin for wet AMD patients. So the Royal College is itself promoting the practice that my clients are seeking to encourage. Then the case is made, well, effectively, well, that's all very well in theory, but in fact, you cannot set up a safe system for delivery of compounded bevacizumab because there are all the risks. And the answer to that point arises in a number of places, but the most convenient place is the recent MHRA report, which is at supplementary bundle B at tab 22. And you've been taken to part of this, but perhaps not the part which is most relevant. Can I invite you to turn up, first of all, at 358? Because at 358, the MHRA notes that despite the concerns about the potential problems of compounding, in the most litigious society in the world, the United States, off-label intravitreal injection of bevacizumab was performed. Bevacizumab has been used for the treatment of exudative AMD worldwide and continues to be the most frequently administered drug for this indication in the United States. And then there is reference over the page F359 to the details about how the US Food and Drug Administration, FDA, the Food and Drug Agency, has developed specific guidelines concerning the compounding process. The position in France is explained at 359. Which authorises off-label use. The position in Italy is summarised at 360. And can I particularly invite the court to read at paragraph 360, the first paragraph concerning the Netherlands.
Well, just looking at France, it says it was issued a temporary use recommendation, provided there's no other product with the same active substance benefiting from a marketing authorisation. But that would be the case here because the active substance in Lucentis and Eylea are different, is that?
Yes, yes. In practice, the temporary use recommendation allows for the French National Health Service. Of course, as I'm sure the court is aware, health services are set up in different ways, and in France, essentially, it's a reimbursement process. So the question is whether or not you get reimbursed for it, and the answer is you do, and that temporary use recommendation has been extended for the further 3 years. But I was inviting, and I'll come to Italy a bit later because it's detailed in the cases. But I invite the court particularly to look at Netherlands at page 360, the reference to since 2012. And that's relevant because in the Netherlands, compounded bevacizumab is the first choice drug, and the state healthcare systems are unlike here, where patients have the right to choose between the 3 drugs. There, you don't even have the right to choose on a state healthcare system unless it's clinically inappropriate. It proves to be clinically appropriate to be treated with CB. And for your Lordship's note, I won't take you to it, there's a synthesis of the evidence at 406 and 407, which reaches conclusions very similar to the NICE conclusions. So what's happened? Our answer to the submission which is made, well, it's not really possible, question from my lady to Mr. de la Mare, is it possible to set up a safe system for the delivery of compounded bevacizumab, is of course it is, because it is being delivered across the world. That's shown, and there's also reference in that document to the position of the WHO, which I mentioned, which I can take you to if you. But it summary says essentially what I've said, which is WHO. This is the only drug which is recommended, and therefore the argument that in sense in practice the risks are so high that you cannot do it is simply untenable in the light of the fact that there are a multitude of other countries in the world that do it, including 4 in the European Union, at least 4, all of whom do it within under the same directive structure as applies in the United Kingdom, at least for the moment.
Just before, well, we've already left NICE, but before we get too far away from NICE, bearing in mind very strongly what you say about this only being relevant to rationality, nevertheless, I wouldn't mind having access to the part of the full report that lies behind recommendation 22, so that one can at least see what the trials considered by the guideline committee were.
Yes.
For reasons of economy, presumably. It was the full report was before the judge, was it?
The full report was before the judge.
You've, I think, only put in the summary and a few pages from the whole of para 10, chapter 10, just check. One.
Yes.
No, not the whole of
it's
it.
not the full.
A few pages from that.
Right.
If you tell me that those are the relevant pages which lie behind 22, that's fine. But I would just feel more comfortable without in any way attempting to sort of judge the NICE report or to award it marks out of 10, at least to see the reasoning that lay behind para 22 recommendation.
Part of that, my lord, is at 331, the very last page in your lordship's bundle, in a paragraph headed anti-VEGF recommendations, which I would invite your lordship to read, as it may assist in dealing with that issue.
Yes, I think what I had in mind was that somewhere it would say what these clinical trials were, who conducted them. I mean, I appreciate you could easily have thousands of pages about that, but presumably there is some sort of summary in this document.
Yes, my lord, there is, and I can certainly provide you the short of German. Essentially what it says is it looks at a whole series of different areas. It then lists all the trials with the numbers, the authors of the trial, and whether it was a trial of one drug against another.
I don't need any more detail than that, and this is very much a just sort of feeling firm ground beneath my feet point. You sometimes just want to see what something is based on. So if you could identify what more might be relevant along those lines, I will not be inviting detailed submissions about it. It's just to know it's there and see what sort of thing it was.
It may assist, but the table summarising the relevant studies is actually then included in the MHRA's report at page 348, tab 22.
I don't want to distract
So
him
just
anymore.
to avoid the need for further pieces of paper.
Thank you very much.
So, my lord, but the essential summary is this. The answer to the question, is it possible to do it safely, is yes, of course it's possible, because EU countries do it safely. The United States does it safely and has detailed recommendations for it. The WHO say this is the way you should do it. And therefore the proposition that you can't do this safely, because in practice the risks that are highlighted by Mr. de la Mare's clients will prevent safe delivery, is simply gainsaid by practical experience. Can I respond to one matter which emerged in the submissions from the learned friend Ms. Stratford yesterday? She correctly identified, and I won't go back to it in detail, that there is a degree of nervousness amongst the clinicians in the various trusts about the proposal for a wide-scale use of the drug outside the terms of its SNPC. And she suggested that the proposals to move from what was the original proposal, which was largely to purchase compounded bevacizumab from a pharmacy in an NHS hospital such as Liverpool, which produced thousands of vials for various of the clinical trials, were lawyer-driven. Now, that's not right. The evidence that these came out of clinical discussions is at supplementary bundle A at page 8 and in the evidence of Dr. Hambleton and the pharmacist Mr. Ray. I'm not going to take you to it, but he explains in detail how this was a clinical process, not a lawyer-driven process, and what they were doing was trying to work out how, if at all, they were going to implement, and mode 1 came out of those discussions. So it's got nothing to do with the lawyers. It's not lawyers making things up for hypothetical. It's the clinicians themselves working it out. So, well, that's part 1. Part 2, policy. I'll just make a few very brief submissions on policy. The decision-making process in the NHS essentially has 2 stages for these purposes. The first is that the CCG makes recommendations in a policy, and then the trusts decide whether to implement those recommendations, and if they do so, the method of implementation. So all the CCG does is put the issue on the table for the trusts who are the implementation decision makers to decide whether they're going to implement, and if so, how to do that. Can I take your Lordship's and your Ladyship to paragraph 39 of the judgment, tab 9, core bundle A, page 145.
So, sorry, which paragraph number?
Paragraph 39, Lord.
Thank you.
My Lord, that is, we say, entirely accurate, and there's no appeal against that decision, that part of the judgment, as I understand it, at any point between 39 and 47, all of which are entirely supported by the various statutory provisions or case law, domestic case law, to which reference is made, and I therefore don't take you through it, save to say it's an important part of the framework within which my clients are obliged to work. But I do invite the court to look at the Secretary of State's skeleton argument on this point, which is at tab 6, and invite your Lordships and your Ladyship quickly to reacquaint yourselves with paragraphs 7 to 11.
So I was just rereading paragraph 39 reminded me that I hadn't quite bottomed out to myself exactly how the relationships work in practice. If the CCG recommends a preference for Avastin,
Yes.
individual trusts, by the guidance they offer to the clinicians, effectively decide that Avastin will be used. Yes.
With strong recommendations to their clinicians, yes.
Yes, well, that's what I was trying to get.
Well, Lord, it's not will be used, will be put on the menu for the choices of the patients.
I understand, because this particular drug we've set up with a system of patient choice, but the intention is that And the expectation is that very many patients will make the choice their clinicians recommend.
Yes.
So the clinicians need to have Avastin available
Yes.
so that if the patients choose it, they can inject it. The trusts, this is the bit I haven't quite bottomed out to myself, the trusts buy the Avastin from whom?
They buy, under this scenario, trusts buy drugs from a variety of people. Some drugs are purchased direct from the manufacturer. Some drugs are purchased from compounders. So many cancer drugs are purchased from compounders that compound them. And then within a pharmacy in the hospital, the drugs are made up for the appropriate patient.
Thank you, that's helpful. But then the real point I was interested in is the CCG has no role in a contractual supply chain.
No, the CCG has a contract with the hospital trust, and that hospital trust.
What is the contract for if it's not to supply? You don't buy through the CCG.
No, you don't buy through the CCG.
No. So what's the contract for?
The contract requires the trust to treat NHS patients that are referred by the GP.
So the contract is to the contract is to treat.
Is to treat.
Yes.
And your lordship may have heard the phrase "payment by results," and essentially.
Sorry, this is all very basic stuff, and once you say it, I knew it, but I
of course
just wanted
no,
to.
No, my lord. The plumbing of the NHS, which would be my specialist subject if I ever went to a mastermind, unlikely as that is far from straightforward. But this bit of the plumbing essentially works this way, that the CCGs contract on big call-off contracts with the trusts to treat patients, defining what trusts are and aren't entitled to treat. If you're within the clinical criteria for treatment, the trusts treat a patient who's referred or who turns up at accident emergency, self-referral, and then, as a result of treating, they bill the CCGs.
So in this case, the bill will say, of course it'll be multiplied 1,000 times, the bill will say, treating Mr. Underhill for his wet AMD, £100.
Whatever is in the national tariff.
Exactly, but a chunk of that will represent the price of the drug.
Yes, though if you, the way the tariff system works is that because these three drugs are under NICE tags, if patients choose the Lucentis, for example, then the tariff reflects the fact that the trust has to buy Lucentis.
Yeah.
And the tariff may be different for Eylea and would be different for Avastin.
So the bill will be made up on the basis of the tariff.
Yes.
And the tariff will reflect the drug used. That's how it comes back.
Yes.
To what payment the trust receives.
Not quite. The tariff is supplemented by local agreements. There would be a local price for treating under Avastin, and the proposal would be that some of the financial benefit from the cost savings would accrue to the trust, and some of the cost savings will stay with the trust. Accrue to the CCG, and some will go to the trust.
And if the hospital decides that it wants to use, or the patient decides they want to use Lucentis, then that will be billed to the CCG, and because it's a reimbursable product, the CCG will have to pay that bill.
That's right, and because Lucentis is subject to a NICE technology appraisal guidance, a tag, that effectively top slices the budget. We're not allowed to restrict patients from choosing that drug, because if you have a drug which is subject to a tag, then the patient has the right to choose. And ground 3 below, which is not persisted in here, is that it undermines the tag to offer another choice, and the judge rightly rejected that because she said, well, there's no question that the choice is still there.
So NICE is NICE also the body which decides that Lucentis and Eylea are, whatever the phrase is, cost effective or whatever.
Your lady is absolutely correct. Yes, they produce a variety of different types of guidance, and I think my learned friend touched on this yesterday. I'm afraid I can't remember which of my learned friends, but they were right. Essentially, there's mandatory guidance and non-mandatory guidance. And if your ladyship's interested, I can take you to the regulations, but I don't think it's necessary.
No.
The mandatory guidance defines certain interventions which, if the patient chooses them, have to be funded by the CCG. And Lucentis and Eylea have mandatory guidance in their favour. But NICE also produces more generalised guidance, where trustees have got a duty to have regard to it. And that's the guidance that I took your ladyship to about the general treatment of wet AMD is in that latter category. So it's not mandatory guidance, but it is nonetheless expert-informed guidance to which trusts are required as a matter of law to have regard.
And that requirement as a matter of law comes from the contract between...
It comes as a matter of public law arising out of a case called Fisher and Derbyshire, which first raised this, and it also appears by way of public law in the case of Rogers, which is referred to at paragraph 45 of Her Ladyship's judgment below. It also arises in respect of a term in the contract. But the relationship between the CCGs and the trusts is essentially contractual, not statutory. So although they're public bodies, they're both public bodies, the relationship is one of contract, not one of discharge of statutory functions. Effectively, the CCG has the statutory duty under the NHS Act to make arrangements to provide treatment, and it discharges that duty by entering into contracts under which NHS trusts treat NHS patients. I hope that's helpful.
Yeah, it's extremely helpful.
That explains, my lord, why the structure at paragraphs 39 to 47 of Her Ladyship's judgment is right. And I don't think it's a challenge, but it helps with the background.
Sorry, I distracted you because you'd already moved on. But I just...
Can I possibly invite your lordships and your ladyship to go back to the Scandinavian Secretary of State? I wanted to make a very short point about paragraph 11. Because what the Secretary of State is saying in paragraph 11 is, notwithstanding the fact that the use of Avastin off-label to treat wet AMD is not within the context of a summary of product characteristics. It's not a sort of licensed, doesn't have a marketing authorization. Nonetheless, the Secretary of State thinks, having regard to the widespread international use of Avastin to treat wet AMD, that CCGs should be able to recommend this treatment. And we see the word recommend in the third paragraph. And the simple submission is that actually that's all we're doing.
Yes, I think the reason why I was a bit uncertain on what ought to have been obvious is that the language of this slightly suggests, it's not quite clear, that the CCG purchases the drugs, which you've made clear isn't the case. But perhaps it means what services to purchase.
I think it means contracts for a third. Either it means contract for a third.
When it says ultimately prescribing and purchasing decisions are one for clinicians and CCGs, clinicians don't decide as such what to purchase, so they decide what to prescribe and administer, and CCGs don't decide what to purchase. So that's a slightly misleading formulation.
It's very difficult for me to criticise the Secretary of State when it's trying to support us, but actually it's not quite right.
That was just what was puzzling me, but thank you.
The reality is, what the Secretary of State is saying, CCGs should be able to recommend treating wet AMD patients. The mechanism by which it happens is that they adopt a policy in favour of it, and then invite the trusts, who are independent decision makers, to make the decision whether to adopt the policy, and if so, how to bring that into effect. But and any purchases, either of Avastin in bulk by way of compounded Avastin from a third party, or buying Avastin and compounding in-house, or original VAR use, are entirely matters for the trust. And the CCG via-res doesn't include, is not a decision maker to force the trusts. They are separate legal bodies. So we are at stage 1 at the moment. We recommended, effectively, we put it on the agenda for the trusts, and the submission is we're doing no more, and have done so far no more, than the Secretary of State thinks we ought to do, which is to recommend. Because, my Lord, because we're at stage 1, no implementation has yet happened, a circular argument is developed by the appellants based on the fact that no trust that presently contracts with the CCGs has implemented. Now, of course, they haven't implemented because of the legal uncertainty of the policy. And what it suggested, as I understand the case that's made against us, is that the fact that we haven't yet implemented, they haven't yet taken implementation decisions, means that you can rule out implementation in any mode other than the mode which was in the contemplation of the CCG at the time the policy was adopted. And we say that's nonsense. And the reason it's nonsense is because the fact that the appellants have so far been successful in preventing implementation, so they continue to ensure that their drugs are purchased, provides no assurance whatsoever as to what decisions the trusts will make, as and when they are confident of the legal validity of the policy. And these are very substantial trusts, and they will make their own decisions, but they haven't done so yet. The method of implementation of the policy envisaged by the CCGs was as I've indicated. But the policy was never binding or prescriptive. It was always optional, as the judge found. That finding is not challenged. And therefore, implementation discussions may well give rise to other modes of implementation, which of course is what happened. And once those modes of implementation are up and discussing, they're not going to be ignored by the NHS trusts. And of course, as the policy is non-binding, it's not only non-binding in terms of whether they implement, but how they implement. And provided whatever they do is a lawful method of implementing, if they choose to implement, they will be acting in accordance with the policy. So the fact that a method of implementation was not in the mind of the CCG at the time that it devised the original policy provides no constraint whatsoever on the trusts.
So a point that was certainly occurring to me yesterday during the claimant submissions was, not quite sure this is exactly how they put it, but it may have been part of it, that the policy is to be criticised because it didn't address the question of implementation, that it's not helpful for CCGs to say we recommend a preference for this or that drug in circumstances where it is known there are big questions about its unusual regulatory status.
Yes.
Without also addressing the trusts about how its recommendation can be reconciled with that unusual regulatory status.
To which, well, I would.
And I think, in
Yeah,
a
I think
sense,
that is critical.
the point you're making is your answer to that. Is that right? That it would be
Yes.
positively inappropriate,
Well,
or at any
no,
rate
it
not
would be
necessary.
possible, but not mandatory. Because it would be possible for the CCGs to have written a book on all the different ways in which you could implement the policy. But the problem with that is, my lord, first of all, these are those are implementation decisions, and the CCG is not the implementation decision maker. And so, whatever legal view, whatever the view the CCGs took of the law in this very complicated area, we would expect, and we know this is the case, that each of the trusts are taking their own legal advice on how to manage their own risks and what is lawful and what is not lawful. And they may well, and we're not privy to the legal advice they've received, and this court will hopefully give some guidance to assist as to what is legal and not legal. But there's no
Don't you have a responsibility? I mean, so you're saying that the policy goes out. We recommend that you prefer the use of Avastin, compounded CB, whatever. Implicit in that is, but you must take your own legal advice, and it may turn out that actually there's no way you can implement this policy without committing the offence of procuring the supply of an unlicensed pharmaceutical product. But you say, well, the policy is still fine, even if there's no way it can be lawfully implemented.
No, I don't.
Well, so where does the borderline lie?
No, if it is correct that we promoted a policy which is incapable of legal implementation, it would be an unlawful policy. There's no question about that. I fully accept that. We've never argued to the contrary. We say there are a series of lawful ways in which the policy could be implemented, but the decision on the choices is for the policy implementer, if at all, which is the trust. Indeed, if the policy couldn't be implemented, it would be unlawful even if in any way, it would be unlawful even if the trusts had all taken their independent legal advice and decided not to implement. It would still be an unlawful policy.
The logic of the submission you were making earlier was, if you approach it strictly logically, that it wouldn't be illegal. You would be saying, we've no idea whether this is legal or not. We can see it's a rather difficult question. All we'd like to say is, if you can do it legally, please do, because there are other advantages. But we wash our hands of the question whether you can do it legally, which also, it's not just a question of law, it's also a question of practicality, because it may well be that the legal questions depend on the practicality questions.
Well, I don't go that far. And my submission was not intended to go that far. I accept that if it has no method of legal implementation, the policy of itself would be unlawful. But if there are a range of possible methods of implementation, some of which would involve acting perfectly lawfully, and others of which may, depending on the circumstances, involve the Commission acting outside the terms of the law, then the policy is lawful, but the implementation decision maker has to make the decision how to implement lawfully, because there is an inequality of expertise here, which is this. The CCG's expertise is in commissioning. It's in deciding what treatments are clinically effective and cost effective, and what to recommend in terms of treatment. The Trust's expertise is in precisely how you deliver treatment and how you set systems up to support the delivery of treatment. Your Lordship is right a moment ago when you said it's not just for the clinicians, because the clinician can't make a decision to deliver Avastin, or offer Avastin to a patient, unless there is a system behind it within the trust which facilitates that decision. And therefore there has to be a system, and that system has to be lawful. We entirely accept that. But the decision about precisely how you source drugs lawfully, whether you source them in the original, whether you compound them in the hospital pharmacy, how they get to the clinician, is all within the exclusive expertise of the trust, not within the expertise of the CCGs.
The policy does go a bit further than you're indicating, because the policy says Avastin will be offered to all new patients.
Yes, your ladyship's right. That's the wording of the policy.
Yes.
But that's why I took your ladyship a moment ago to the effect of the what the judge decided about the effect of the policy. And whatever the wording of the policy is, the decision-making processes within the NHS mean that it can't be anything more than a
In a
strong
sense,
recommendation.
would this be a correct paraphrase of what you're saying? The policy, in the sense of the document we got behind tab 18, is actually a recommendation of the policy that each individual trust should have. It should be the trust of the policy of the trust
Yes.
to have a preference for Avastin,
Yes.
and we are recommending that that be the policy.
Yes, precisely. And of course, that must be right, my lord, because it's the trusts that treat the patient. And the policy is about what patients get, and control of what patients get is exclusively within the decision-making of the trusts.
Right, but if the policy was adopted by the trust, that would then contemplate a certain volume of CB
Yes.
being acquired.
Yes.
And the question is then whether there is a legal way to acquire that volume of CB.
Precisely. And it's the system that lies behind the clinician, which would be the focus of any challenge to a decision by the trust. I imagine that the challenge would not be you're using drugs off label, unless the extreme position taken by the level from Miss Stratford is adopted, but putting that for one side a moment. It's not the challenge would not be to the fact that patients are being provided with CB to treat their wet AMD. It is the system behind it for the sourcing of the drug, and the question is if that system is lawful or not. And if that system is lawful, there's no problem with the policy, we would submit. If that system is unlawful, it's the decisions made by the choice about the system, which is where the illegality lies. So that it's some way detached from the CCG. So coming back to where I started, which is paragraph 11 of the Secretary of State's skeleton argument.
Can I just ask one more question before I let you
course,
do that? And again, perhaps not. It's just it's a thinking aloud in case you have a comment on it. I certainly had a slightly unformulated impression when you talked about the inequality of expertise that actually that all the expertise in this area was in the CCGs, that the CCGs in practice, in other way around, the trusts in practice, perhaps not in law, delegated to the CCGs their whole thinking on this question. You're saying not so?
No, not so. CCGs are membership organisations of GPs. So the members of a CCG governing body are predominantly GPs with with some non-executive directors. They are commissioners, not providers. Their job is, as rightly described by the judge in paragraphs 37 to 47 of the judgment, 36 to 47 of the judgment, which is to assess what medical treatments are clinically effective and cost effective, and as that side of the expertise they are able to do. But the precise way in which oncology drugs or orthopaedic operations are carried out, and how, for example, the various implants that are used for orthopaedics are sourced and what sort of orthopaedics implants should be sourced. The whole procedure of the delivery of healthcare is exclusively within the expertise of the trusts.
Would either the individual CCGs or a consortium, that's probably the wrong word, of CCGs such as we're dealt with here, have any large administrative staff? Would there be, there as were in-house people who could advise them on decisions of this character? I've no idea what the setup of a CCG is, or of a group of CCGs.
Well, the answer is some, but limited. They're essentially administrators, they of course can buy in expertise. But as we've seen from the correspondence here, it is the expertise on pharmacy matters. The head pharmacist at a trust is a very important person in respect of running his own pharmacy and being professionally responsible for what happens there. The clinicians, the ophthalmologists, are the ones who in the end will talk to the patients and make decisions. And there is a very delicate balance in the NHS between the clinical freedoms of the clinicians to do their job in the way they think appropriate, and managers, many of whom are not clinicians, some are but many are not, in putting constraints on that clinical freedom. And the clinical freedom of pharmacists and clinicians to take decisions in ways they consider to be in the best interest of the patients they serve is jealously guarded. And the expertise about how to set systems up to support that is equally jealously guarded by the professionals, who in this case are all in the trusts.
Sorry, I've distracted you a good deal, helpfully to me
Not at all.
anyway. But I'll try and keep quiet now.
Not at all. So essentially the position is this. We would expect the NHS trusts, we have done stage one, and His Lordship rightly focused, what essentially we're doing was inviting a policy for those who treat the patients to adopt. And we would expect the trusts to take their own legal, clinical, pharmacy advice to decide how they are going to deliver on the duties they've got to patients, because they're the ones with the legal duties to patients, in making the decision whether to implement the policy, and if so, how to do that. And if they're going to do that, what systems exist behind the clinician-patient interface to allow the clinician to have the Avastin in his hand, or her hand, at the point that the patient makes the choice. And it goes no further than that. So,
as I understand it, you accept that there must be, for the policy to be lawful, there must be one lawful method of implementing it.
yes, I do.
So doesn't the CCG have to get to that point, satisfying itself that there is a lawful method?
Yes, and the CCG,
And also,
my lord, yes.
does it go further? Second part of my question would be, do they have to consider whether it's practical and realistic, or is any theoretical way good enough?
Well, my lord, let's imagine an extreme scenario and test your lordship's scenario. Let's say that we were definitively clear that modes 2, 3 and 4 were unlawful, and therefore we wouldn't achieve the savings that we hoped for by the policy. I pause and say a policy is not unlawful if the savings anticipated don't materialise. Otherwise, virtually every policy across Whitehall would be unlawful, because the savings are never generated, they're always too optimistic. So in fact, you would be delivering the policy by original vial use, but so the policy would not need any change to its wording, but all the other routes would be closed off. And let's also say that, having been through that exercise, original vial use was not what you had in mind at the time you adopted the policy, but has come out of clinical discussions, as it did and then is identified as the only way, lawful way of delivering. Is the policy therefore lawful? Should it be quashed by the court? Well, the answer is plainly no, for one very simple reason, which is that given that framework, you quash the policy, the following day the CCG adopts exactly the same policy, but this time has in mind regional values, doesn't need to say so. And you've then got a policy which is quashed and a policy which is entirely lawful with the same words. And that's a nonsense. So the answer, my lord, is that as long as there is one realistic method of implementation, and we know regional values is now realistic because that's come out of the clinical discussions with the trusts. It was their idea. The wording of the policy itself, therefore, must be lawful. Sorry, Mandy.
But it's not really the savings that are the point, it's the scale that's envisaged. And I don't know whether, in fact, you could use Avastin on the scale that's envisaged by using mode 1. And you could have all new patients and switch patients onto CB by using mode 1, sort of immediately as the policy envisages. But if the only lawful means is a much more restricted means, using with a requirement of a prior prescription, for example, or only being used in an exceptional circumstance, so that the scale, or the only lawful ways of acquiring it, can result only in very few or far fewer uses of it than are envisaged by the policy, would you say that that would make the policy unlawful?
Can I take that in chunks, because the number of scenarios have been put. Firstly, original values. Avastin is a drug which is available on the market. There's a certain amount of evidence of the quantity. It's freely available to purchase. If the trust took the view that purchasing a vial of Avastin for each AMD patient at about £290 was and using a part of it and discarding the rest, was preferable to spending something like double that on Lucentis or Eylea, there's no reason to think that the market could not provide as many vials of Avastin as the trust chose to purchase. The fact that it would be used off-label is not a bar, we say. I'll come on to that after. I imagine afterwards. In those circumstances, there's no reason why scale can't apply. The only restriction would be that can you get the Avastin? And the answer is it's a very common drug, and there's lots of it around, and they would be able to get it. Secondly, the leadership said, well, what happens if you introduced a qualification that this was not a drug of choice, but was a drug which is only used in exceptional circumstances? Those exceptional circumstances being, for example, because you're allergic to either of the other two drugs, well then you're in the category of specials. So the policy wouldn't be needed at all, because there already would be a perfectly valid reason for using Avastin in those circumstances. So the policy, by definition, applies to choices for all patients, and it's perfectly capable of being delivered by regional values. We wouldn't get the full savings, but we would get considerable savings. And therefore the only objection to that would be, as a matter of principle, whether we're acting unlawfully by preferring an off-label use rather than an on-label use. And I'll deal with that in the next section of my submissions. But that would be a perfectly proper way to implement the policy, taking adopting what my Lord Justice Underhill said, the trust would adopt precisely the policy, which is we give choice, and the administrative system sitting behind that choice would be a regional VAR use. And a regional VAR use would be perfectly lawful, we say, and if that's right, the policy.
Okay, but you've chosen the easiest part to deal with at length. Let us suppose, don't worry about what reason, but legally say, but because it wasn't in your mind at the time, whatever, mode 1 isn't available. I suppose it isn't available. What about modes 2 and 3?
Well, my Lord, can I take the other alternative, which is this? Let's assume that the trust said we're not going to compound in-house, but we are prepared to purchase it from Liverpool. They have a perfectly proper system, and Liverpool and the trust legal advice says, right, well, if that's the system you want to set up, the process has to be you see the patient first, make the choice, write the prescription, send that off to Liverpool. Liverpool does the compounding and then supplies the trust with the drug. Now, one of the features of this case is that this is a drug with repeated usage. So once a patient is on the drug, they come every 4 to 6 weeks for a period of years and receive the drug. So a hospital will have a cohort of patients on wet AMD treatment at any one time, and people will be coming in, mostly elderly patients, for their injections every 4 to 6 weeks. And people will come into that cohort when they're newly diagnosed, and they will drop off that cohort for a variety of reasons. The patient may die, the patient may decide they don't want any more treatment, the treatment may not be producing any clinical benefit, and therefore you drop off the other end. But essentially there is a reasonably fixed cohort of, say, 300 patients. And 1 month it'll be 300, the next month it'll be 205, then it'll be 292, and that's the way the system would work. And in those circumstances, the prescriptions will, as prescriptions often do, cover multiple administrations, because prescriptions are not required. It's not actually in hospital it's referred to as prescriptions, but it's a medicines authorisation in hospital, and it's exactly the same. The authorisation will cover multiple administrations, because you anticipate that Mrs. Jones will be treated with Lucentis or Eylea for the next 6 months, and that's what the authorisation will provide. And therefore the hospital will have a stock of authorisations for the cohort of patients to manage this process. This is all that goes on behind the process. So obviously in setting up a system, if advanced patient prescription is necessary, my submission is actually there already. If it has to be sent to Liverpool, so they have a list of the prescription, the patients and the prescription numbers, that's an administrative task, and it's part of the system that would need to be set up to deliver that mode of implementation. The crucial question, and that, if that is the system, if that's what the NHS has to do in order lawfully to deliver this system, that is what the NHS will do. It is
or will choose whether to do.
Or
the
choose
point
whether
may
to
come when it say it's too difficult, or
Precisely.
It has administrative costs.
It may be that the cost of this administrative paper chase is thought to be too great, though the savings are very substantial. The question, my Lord, though, coming back to the first question, is does the requirement for individual prescriptions have to be in the CCG policy? And we respectfully submit no, because it only arises if the implementation decision maker decides to implement in a particular manner which requires individual prescriptions. And if that happens, then the mode that you choose will have all manner of requirements, one of which may well be individual prescriptions. And that's the way that the trust, as the decision maker, decides to implement the decision. And if their lawyers say, we carefully consider the judgment of the Court of Appeal, and you have to have individual prescriptions, and they have to be communicated to Liverpool, and the trust says, okay, that's fine, that's our decision, that's how we're going to do it, then that's their operational policy. But the detail is in their operational policy, not in the CCG general encouragement.
But when you say, you indicated then that there's a sort of mass prescribing takes place, I didn't quite understand whether you say that for a particular person there's one prescription for a year's worth of treatments for that.
Yes, my lady.
Yes,
yeah,
rather than saying,
yes.
oh, well, this month we're going to need 300, so it's right. But then doesn't the shelf life issue become absolutely crucial? Because it's fine to have a prescription for a year's worth of injections if the shelf life of the product is 2 years. If it's 7 days, then it makes it a completely different exercise.
My lady, I'm not a pharmacist, but I have
Well,
spent
neither am I, but
but I've spent a lot of time talking to pharmacists. Can I explain to your ladyship why that concern doesn't actually rise in practice? And I have a pharmacist behind me, and at the short German, if I get this wrong, he will no doubt correct me. In fact, I suspect he's going to correct me whatever I say. My lady, the provision of a medicines authorisation signed by the ophthalmologist gives, which says we're going to, Mrs. Jones is going to have monthly injections, gives authority for the pharmacy at the hospital to release the drug for the particular outpatient appointment that Mrs. Jones will attend. The responsibility for making sure that at each appointment the drug is within the shelf life, whatever that is, rests with the pharmacist in the pharmacy who is sending the drug off to the outpatient clinic, not with the original doctor who makes the prescription.
If I can just understand that in my own language, you say you have a prescription for a year, say for, make it easy, monthly, so 12 prescriptions. That doesn't mean, in practice, we'll decide whether this is also what the European Court meant, it doesn't mean in practice that the pharmacy makes up there and then, on receipt of the thing, 12 syringes and puts them in the fridge with Mrs. Jones on them.
No.
It means that it has a system whereby a couple of days before the monthly appointment, it either makes up a syringe for Mrs. Jones, or perhaps, if this is lawful, has made a number of prescriptions that week, and they're sitting in the fridge, and it takes one out and marks that for Mrs. Jones. But it doesn't. Have I got that right? Is that how it would work in practice?
My lord, there are times when having an expert behind you is absolutely fantastic. Can I give you the precise language on this note? You can draw down against a prescription. So I think that's precisely what
who draws down
the pharmacist draws down again.
I think that's what I described.
Exactly.
The prescription says a year's worth, but you draw down every month.
You draw down in a way which is clinically appropriate within your expertise as a pharmacist. Bearing in mind, you're not the person who wrote the prescription, that's for the doctor, because the doctor does the diagnosis and works the treatment plan. But your expertise as a pharmacist is to make sure that whenever drugs leave the pharmacy for intended use, they're clinically appropriate, and that's one of the things in the shelf life. So the point that the ladyship raised is a proper one to raise, but if you draw down against a prescription, then that's the scheme, it doesn't arise in practice, because what the pharmacist is doing is making sure, as pharmacists do, that regardless of what's on the prescription, the substance which leaves the pharmacy is clinically appropriate for that patient. And keeping it within shelf life is one of those issues.
Seems to be inherent in that our sort of general understanding of what's on a prescription, which we've probably all seen, is insufficient, because these authorisations that you're talking about must not just specify what the pharmacist has to dispense, but when as well.
Well, they would be an authorisation for vials of Avastin.
Or
As
do
I
you
understand,
mean, like, if we're talking about modes 2 to 4, you mean syringes?
syringes, yes, containing a certain amount of Avastin. So that would.
You're saying that somehow Liverpool, in your example, get to know not just that Mrs. Jones is on a course for the next year or so, but Mrs. Jones has appointments on the 1st of January, February, March.
No, my lord. The prescription. The prescription sets up the medicine's authorisation for the delivery of the drug to Mrs. Jones. Then what happens is the pharmacy get told separately, Mrs. Jones is coming in for appointment on Tuesday. So when you prepare the drugs for the outpatient appointment on Tuesday, at that point you will need to have a drug which satisfies Mrs. Jones's needs. At that point, Mrs. Jones, the pharmacist will make sure that the drug that moves from the pharmacy to the outpatient appointment is within time, is the right dose, and is there appropriate for the ophthalmologist to administer the injection. But as far as Liverpool are concerned in this example, Liverpool will be told we have prescriptions for 300 patients for this next month, and they're all written, so that so the clinical decision to offer this treatment will have been taken. But the precise way it then works out in practice, once that medicine's authorisation has been generated, is then a matter for the professional pharmacists, not the doctor, because the doctor bookends the process. The doctor is concerned at the diagnosis and prescription in the initial stage, and then turns up at the outpatient clinic and miraculously a vial of Avastin of the right quantity is there to administer. Everything that happens in between is the responsibility of the professional pharmacists. I hope that's helpful.
It sounds as if there is some stocking of the syringes then involved.
Well, one of the points I was going to make in respect of individual prescriptions that I'll come on to, I anticipate this afternoon, I'm trying to make some progress, is that the process that the paper chase that the trusts, the pharmaceutical companies are attempting to impose to avoid any stocking is actually very substantially bad for public health.
But it's not they're trying to impose it. I think where we get to is that if the conclusion is that there has to be a prior prescription on the basis of the CJU's case law, then somebody is going to have a very serious look at that case law and at how pharmaceutical products are ordered and stored and got to the patient to see whether the system that you describe is already adaptable or needs to be changed to be adapted in order to meet the requirement that the court has emphasised for there being a prior prescription.
But it is absolutely right. And if it is the case that there must be a prescription in place, I make two submissions. One, the place for that in terms of where it appears is the operational policy of the trust, not the CCG's policy, because it arises out of a choices of mode of implementation. Secondly, that process, if it is to operate in these days of electronic data transfer, and given the stable cohort that we're talking about, which is largely stable, and indeed the medicines authorisations covering multiple administrations, one can see how it could work perfectly easily. It needs some software, it'll be a bit complicated, but if that's what's taking, that's what's necessary. But thirdly, that's the crucial point, if that is possible, if that is required, the savings for the NHS from implementing this policy are so huge that there is more than a reasonable expectation that setting up a system of that sort will happen.
The way this all fits into your overall submission is you don't have to prove the details of how it would work. At worst for you, you have to show that it's not fanciful.
Yes.
I think on one view of your submissions, you don't even have to show that, but you just say, well, it's a problem for the trust, and if it doesn't work, it doesn't work. But I don't think actually you're going quite that far. You're saying if it's obviously fanciful, then it will be unlawful to recommend it.
Yes. But I'm saying, my lord, that the NHS operates a series of enormously complicated systems to deliver healthcare. And some of the processes that are of delivery are of mind-blowing complexity, but they happen all the time. And those who are concerned with these matters do not share the pessimism that it's not possible to set the systems up.
I appreciate we're taking you off from the submissions you want to make, but this, as you can see, is really the heart of one part of the case. Can I just, all this spun off from a question from my lady about the degree to which it was necessary in order for the policy to be lawful, for it to be not merely be routes that are legally possible for it to be implemented, but routes for it to be practically possible.
Indeed.
And one aspect of that is certainly a prior prescription only system, and that's what we've been looking at. The other big area, which is relevant to mode 2, so if you can't buy from Liverpool, and you can only do this by having your own system, is the question of whether it is realistic to think that individual hospital pharmacies, which are not, it seems, generally at present tooled up to do this, would make the investments to enable them to do so. Now, is that a question on which the commissioning groups ought to have formed a view that it was realistic before issuing the policy?
My lord, no, because the evidence helpfully or otherwise produced by the appellants in this case has shown that 3 out of the 5 hospitals say they have facilities that could be used for this compounding. At the moment, those facilities are used predominantly for specials compounding, but whether they could be extended for this type of compounding would be a decision for the hospitals. So knowing the hospitals on their own patch, they already know that 3 out of the 5 big hospitals have the capability.
They're compounding this drug.
No, they're compounding other drugs for specials, my lord. My lady, they may well be compounding this drug if it comes in as a special, because as your ladyship's heard, it's used for a number of other drugs where there isn't an on-label alternative. But the compounding, but the facilities at trusts, pharmacies, are very substantial. And the question as to whether or not the additional investment would be put into those pharmacies in order to do in-house compounding, and it would require investment, I don't dispute that, is precisely the sort of post-implementation discussion that the NHS has all the time. And of course it's all terribly circular, because if they need a prior prescription system to compound it out-house but don't need it in-house, and I'll be making submissions this afternoon, very clearly don't need it in-house. It's arguable whether they need it out-house, but we can debate that. But if the position is they don't need it in-house, then they have to do a cost-benefit analysis if they want to implement the policy. How much additional revenue will we get from switching patients to Avastin? Because we'll get more in our PBR payments we'll get more profit in our PBR payments than we would do if we get
PBR?
Payment by results, my lord. Sorry. How many patients do we think we can switch? How many will choose? Does that justify the potential investment over a number of years working out the policy? How long is the kit going to last? How many additional pharmacists and pharmacy technicians are we going to have to employ? It's quite a complicated process. But those are all decisions purely within the expertise of the trusts, because they're business case decisions about the way they manage their complicated business. They're not within the expertise of the CCGs. And my lord, it is a bit circular, because it depends how much it would cost them to set up a system for prior patient prescriptions to get it from Liverpool, and how much Liverpool would charge.
It may also be a question, but as we shouldn't go there, about whether Liverpool could cope with the demand if everybody did this.
Well, if everybody did this, then of course, my lord, that would put enormous strains on the system. But that's an operational issue. It's not affecting the legality. That's a problem of success. And we're concerned with failure, not success. But, my lord, so the answer as to whether the CCGs should have gone through a hypothetical exercise to work out if they were likely to do this, in my submission, no, because it clearly was an option. But the first question for the trusts is it lawful to do this in various of the modes? Once that's been answered, we anticipate the trust will go to the business case issue as to whether or not they're going to do it, bearing in mind they're under no compulsion to do it. And it's not for the CCGs, who don't have this expertise, to devise a policy and start second-guessing those who do have expertise about a series of decisions concerning a framework of which they know little, investment criteria that they're not in control of, and indeed is commercially confidential from them, and to an outcome which is dependent on a whole series of legal, professional, pharmacy, clinical advice. So all the CCGs can do is in my submission, do what they've done, which is to say, this is what we'd like you to do, this is the direction of travel. But the precise vehicle in which they travel has to be for the trusts, because they're the ones who know the details of the vehicle.
Well, that's where you came in about an hour ago.
I
No, but that's not a criticism of you. Well, I think we've really done that aspect
I have.
to death, I think.
I have. I'm sorry, I've been trying to answer your lordship's
No,
question.
the criticism, I said it's not a criticism of you at all, but I think we probably
Let's move on.
extracted your case on ground point 2. So that's fair? Yeah.
Can we move to point 3? And this is where the meat of our substance is. I'm going to take a little time to deal with the case. As I understand it, the essential case is this. What the appellants say is that CB is an unlicensed medical product. They say any supply by a commercial compounder or a hospital pharmacy constitutes a placing on the market, whether it's Liverpool supplying Newcastle or Newcastle supplying its own patients. They say Article 3 and Article 5 they don't apply. They say no one can place the CB on the market unless they've got a marketing authorisation. No one's been granted a marketing authorisation for CB, and hence a policy which is predicated on an assumed unlawful supply of CB, is itself unlawful. And they say mode 2, which is in-house compounding, is just as much a placing on the market as mode 3, which is hospital A supplying hospital B. And they say in any event, you're not allowed to look at modes 1 and 2 because they weren't in the mind of the trust, the CCG at the time. I dealt with that. And we submit this contains a series of erroneous approaches. The directive, my lord, my lady, imposes rules which govern the operation of the economic market in medicinal products by imposing obligations on those who are manufacturing drugs, where there may need to be a manufacturing authorization, or those who are placing drugs on the general market for sale, where there may need to be a marketing authorization. So the proper question under the directive is not whether a medicinal product is licensed or unlicensed, but whether, in particular defined circumstances, the express terms of the directive mean that a person who proposes to perform a particular function with respect to a medicinal product either needs a manufacturing authorization or a marketing authorization in order to be lawfully able to undertake that function. And public health is protected by limiting the operation of those who are functioning in the economic market for the drug supply chain, by imposing rules on those market actors to require either a manufacturing authorization or a marketing authorization. But there are specific exemptions under the directive to deal with the actions of medical professionals who are involved in the supply of drugs, in the supply chain, where public health is protected by the fact that it's being done by a medical professional, notably a pharmacist, and therefore they are exempt from the usual rules of the directive. And therefore it is the function by a market actor in this clinical, in the supply of drugs, which is regulated, not the medicinal product itself. And can I invite your lordships and your ladyship to turn supplementary bundle B, tab 22, page 367. And invite the court, if you'd be kind enough, to read the paragraph headed "What is an unlicensed medicine?"
This is the MHRA's clarification.
Sorry, I should have mentioned. This is the MHRA's revised guidance. And in summary, we agree. It is the placing on the market which is regulated, not the thing. So it's an error of law to describe a medicine as an unlicensed medicine. The question under the directive is whether a person who undertakes a function with respect to a medicinal product requires either a marketing authorization or a manufacturing authorization in order to undertake that function. Now, any supply by a commercial compounder or a hospital pharmacy to a hospital, from hospital A to hospital B, would not be within the scope of the directive if Article 3 or Article 5 applies, but we don't suggest that Article 3 or Article 5 applies. And the decision of the CJEU in IFA, which is at Authorities Bundle 3, tab 29, the reason that Article 3 doesn't apply, even if there's a prescription, is summarised in paragraph 717, page 717, paragraph 58. I know the court will have read these judgments and will read them and may well look at them again before producing judgment.
They repay reading and rereading.
I'm afraid they do. It's 717, my lord, tab 29.
That's as bundle C.
It's bundle C, yes. And if I can invite the court, you kind of have to read paragraph 58. So essentially what the court is saying is that Article 3 says you're exempt from the directive, and including exempt from the downstream pharmacovigilance requirements. So you're out of scope of the directive if a medicine is prepared in a pharmacy by a pharmacist against an individual prescription. But the mere compounding of Avastin, where the essential active ingredient is not changed, simply put into a smaller vial, is not preparation.
That obviously is with reference to the processes described in the file before the court,
Yes.
but you say those are, we haven't got the file before the court, but it's clear enough that those are the kind of compounding that would be envisaged here.
Yes, because the file before I can take your lordship's and ladyship to the facts of this case, but essentially the process in Italy was that Hospital A compounds the, with special authorisation, compounds the Avastin into separate vials and then supplies it to the specialist hospital which does the administration. That happens under a series of rules which we see, my lord, at 713. Those are the rules as to how it has to operate. And just to give a flavour of what I'll be saying later, interesting, those rules do not refer to or require prior prescriptions. They require prescriptions, because of course this is prescription-only medicine, but not prior prescriptions. My lord, so our submission is that
So I'm probably being very, very slow, but this is saying that necessary processing that goes on does not amount to preparation
yes.
of a new medicinal product. So what does amount to preparation of a new medicinal product if changing the indication and the form in which it's supplied and just about everything else about it
Yeah. Well, very interesting question. Presumably adding.
is not preparation. preparation is what? Synthesising it.
It must be, my lord. It must be adding two drugs together. My lord, I'm not in a position to assist you, lordship, what's in the mind of the judge of the European Court.
I'm just trying to test
But
to understand what they might
if you added another drug to it,
Yeah.
my lord, essentially the submission I will be making in due course, again, I'm sorry, giving you advance notice, is that this is all connected in to Article 42 bis, which gives pharmacists the right to divide up drugs. If you just divide up a drug by separating it into smaller vials, then you're out. Then you don't need a manufacturing authorization. And what this is saying is that the process of dividing up.
So is it applying 42 bits by analogy to marketing authorisation?
Well, not quite, my lord. I think what it's saying is that the function that you're undertaking by dividing up for retail sale keeps the drug within the scope of the directive, because of course Article 3 takes it out of scope. And the reason that it does so is because what you're doing is something which has already been envisaged by the directive, namely a pharmacist dividing up the drug, because that's allowed.
Dividing it up in this case is sending it off for a new indication.
Well, my lord, it's dividing up for the purpose of retail sale. My lord, can I come to this a bit later, because I hope it will all make sense.
Thank you.
But my lord,
That's probably putting down a marker that it's not making a lot of sense.
no. My lord, trying to make sense of this process is. I don't have the sort of flair and energy of my learned friend Mr. Delamere. Trying to make sense of it is not straightforward for anybody. But my lord, can I though have a look at the fundamental structure of the EU in this regard by looking at Authorities Bundle 2, tab 9, which is the consolidated version of the Treaty of the European Union. Which I know will be extremely familiar reading for all of the court. So I'll take it at some pace, if I may. Article 4.1, top page 341. In accordance with Article 5, competence is not conferred on the Union in the treaties remain with member states.
Not sure what these noises are. I suspect they're to do with the
Article 4.2, Union shall respect the equality of member states, all treaties, as well as their national identities inherent in the fundamental structures, political, constitutional, inclusive, and local self-government. It shall respect the essential state functions, including ensuring territorial integrity of the state, maintaining law and order, safeguarding national security, and so on. And then Article 5, the limit of Union competence is governed by the principle of conferral. The use of Union competence is governed by the principle of subsidiarity and proportionality. Under the principle of conferral, the Union shall only act within the limits of competencies conferred on it by the member states in the treaties to obtain the objectives set out therein. Competencies not conferred on the Union in the treaties remain with the member states. And that fundamental division is of some importance. Moving on, my lord, there are shared competencies in limited areas of public health, and we see that from tab 10, TFEU, Article 4, the Union shall share competency with member states where the treaties confer on it a competence which does not relate to the areas referred to in Articles 3 to 6, and then the shared competencies are listed, and public health is at K, just over the page, common safety concerns in matters of public health for aspects defined in this treaty. So it's not all public health, it's only public health issues which give rise to common safety concerns, and that they would typically be infectious diseases, where a person who has infectious disease plainly travelling from one country to another.
What does the phrase for the aspects defined in this treaty mean, which is peculiar to K, as it is?
It is, my lord, and it defines, so the public health element is at page 347, and I think what it means is as defined in this title.
Yes, I see. Thank you.
Article 168 1. A high level of human health protection shall be ensured in the definition and implementation of all union policies and activities. Union action, which shall complement national policy, should be directed towards improving public health, preventing physical and mental illness and diseases, obviating sources of danger to physical and mental health. Such action shall cover the fight against major health scourges by promoting research and so on. What I invite you, the court, to draw from that is that if a function is a public health function is ascribed to the union, those are the principles with which the public health function must be discharged. But that is not of itself giving any additional competency in public health matters. And then we come over the page at 348 to 1687. Union action shall respect the responsibilities of member states for the definition of their health policy and for the organisation and delivery of health services and medical care. The responsibilities of the member states shall include the management of health services and the medical care and allocation of responsibilities assigned to them. We submit that the union is required to respect the right of member states to organise the delivery of their own health services, including the way that those health services are managed. And we submit that this requirement to respect the way services are managed within member states extends to the way in which one part of the NHS compounds CB for another part of the NHS, just as if it was all compounded in the same hospital.
Of course, it's not all that long ago, you will know, when there were no separate legal entities within the NHS at all. It was all the Secretary of State.
Precisely.
I can't remember, when was that changed?
The NHS and Community Care Act 1990 that was implemented in 1993 that gave rise to the first NHS trusts that were I think it was the area health authorities at that point. I can't remember what they were called, but essentially they ran everything other than the specialist trusts. So trusts
I see.
were
So in
created.
fact, it's longer ago than I thought, but still, it's an interesting thought experiment.
Of course.
That if this was 25 years ago, it would all be a single legal entity. The
Yes.
whole of the NHS and area health authorities had no legal capacity, did they? I mean, they had various fake capacities for the purpose of employing people and so on. But
That's right.
yeah.
And it remains the point, my lord, that NHS trusts, with the exception of NHS Foundation trusts, that have arrangements with each other, do not sign legal contracts. They sign what's called NHS contracts, which have no legal status under Section 9 of the NHS Act. So effectively it's an internal arrangement, no more than the arrangement between the central office and the photocopier, under which whoever does the photocopying then recharges your department for the cost of the photocopying. It's an internal service charge arrangement within the wider NHS, as opposed to being an external contract. So these are separate legal bodies, but the way that they set up arrangements with each other is very particular because they are within a state healthcare system. Now, the CJEU has repeatedly rejected the submission that the Medicines Directive prevents the systemic promotion by state healthcare bodies of the use of medicines outside the terms of its statement, SMPC. And this issue has been repeatedly raised by pharmaceutical companies who essentially want NHS bodies to work to the same rules that they are, so it's the supplier wanting the customer to work to the same rules. And this has been consistently rejected. It was raised in the AGCM case, which, my Lord, is at tab 27 of bundle C. And I simply invite the court to read paragraph 48 of the opinion.
Page 668.
Sorry, 632, my lord.
Oh,
I'm starting off with the Advocate General
oh, I see. Of the opinions. I'm so sorry.
of the opinion.
Yes.
I'm sorry, I should have mentioned that. 632, AG 48. And the final sentence looked forward to the case which then became AFA in due course, and that's a reference in the footnote to the case that then became AFA. And that's picked up in the judgment at paragraphs 48 to 51, page 716. I'm sorry, I've got that wrong. Accepted by the court, page 669.
Sorry, which paras? 40?
58 to 59 at 669 in the decision of the court.
58
in
to
AGCM.
59, 669, okay.
And I invite the court, if you'd be kind enough, just to remind yourself of those two paragraphs which summarise the submission I made, that essentially the repackaging to promote off-label use is not prohibited by EU law.
Yep.
And next, going to AFA, if we can, starting off at the opinion of the same Advocate General at page 696, tab 28.
Sorry, which
This is
which paragraph?
paragraph 102, my lord. 696. And it's paragraph 102 and 103. again, I won't take the court to it, but for the court's note, that is adopted by the court at paragraph 48 to 51, tab 29, page 716. And therefore, the way we put our case on this point below is set out in our skeleton, and I won't take the court to it, but for reference, it's core bundle 2, tab 13, at page 347 to 350.
Paras.
53 to 57. But just before the short adjournment, I would take the court, if you'd be kind enough, to the judgment below, where the judge gave her decision on this point at 140 to 147, tab 9, page 172. Paragraphs 140 to 147.
Well, I imagine you're not asking us.
I'm not asking
all
you
of those.
to read it, I'm merely asking you to note. But it's important for this reason, my lord. A number of points come out of it. Firstly, there is nothing unlawful under the EU Medicines Directive in the systematic promotion of an off-label use of a medicine by a state healthcare body, even if there is a licensed medicine, if I can use that phrase, but with its caveats, as an alternative. And this is an unusual position because this court is not being asked to make a jump from another case and another factual scenario, because the cases that have been before the European Court have been about the use of Avastin for wet AMD. And therefore, the court's view as to whether or not it's systematically unlawful is precisely on point. And secondly, that the reason that it's not unlawful is because the EMA does not have an exclusive competence to decide either what drugs are safe or clinically effective, or what drugs should be used for patients, for the simple reason that is made in a number of the cases that the EMA is only able to deal with applications made by pharmaceutical companies, and therefore is limited to adjudicating on a particular application. And the pharmaceutical companies, if they choose to put themselves through this process, obviously subject to the full rigours of the process, but they can't say that a drug which has not been put through this process, because they've chosen not to put it through the process, cannot be assessed for its clinical effectiveness, its safety and its cost effectiveness by a state healthcare body. The state healthcare body is perfectly entitled to reach its own views about whether the drug is safe or clinically effective. And as long as the rules of the market, of the economic activity in the drugs market are not transgressed by the way that the drug goes through the supply chain, decisions on use and recommendations for use fall within the exclusive competence under 1687 and are solely matters for national bodies. Well, is that a convenient moment?
Which you would like to break. Yes, thank you very much. 2 o'clock.